Thank you for joining us this morning for this conversation. It has been 2 months since the International Court of Justice issued provisional measures in South Africa's case against Israel under the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. The court found it plausible that Israel was committing the crime of genocide against the Palestinian people and issued legally binding provisional measures, directing Israel to take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Genocide Convention. South Africa has since filed 2 urgent requests with the court for indicating additional provisional measures, first in February and then in March. Since then, in the last 2 months, we have witnessed that the genocidal assault on the Palestinian people by Israel has only gotten worse in breach of the ICJ's preliminary measure order. Last week, we at Law for Palestine, with the support of the Independent Commission for Human Rights and the Arab Network for National Human Rights Institutions, submitted a 200-page communication to the ICC, highlighting the process of genocide against the Palestinian people in Gaza, in the West Bank, East Jerusalem, and the larger context over the 75 years as a tool of colonial apartheid regime that it is. Francesca, in her report that was published yesterday, Anatomy of a Genocide, concluded that there are reasonable grounds to believe that the threshold indicating Israel's commission of genocide is met. And yet, as we speak, the genocide continues unabated. Against this background today, we gather here to talk about the legal obligations on third states as signatories to the Genocide Convention in preventing genocide and implementing the ICJ order so far. Without further ado, we will begin this conversation. I will give the floor now to Ola Adawi, the International Relations Officer at the Independent Commission for Human Rights in Palestine, who will speak on behalf of Mr. Issam Aruri, the Commissioner General, who was unable to join us today because of visa issues. Just to give an overview of where we're at. Ola.
Thank you, Anisha. Good morning, ladies and gentlemen, and thank you for joining us today. On behalf of Palestine Independent Commission for Human Rights, I would like to extend my thanks to Law for Palestine, Human Rights Watch, and our long-lasting partner, the Arab Network for National Human Rights Institution, for co-organizing this event. Our appreciation also extends to the distinguished speakers whose expertise and commitment to human rights offer hope in these trying times. We meet at a critical juncture. In Gaza, civilians are facing dire conditions, fighting for survival every second. Even with the Security Council's immediate ceasefire order last night, the Israeli military continued its attacks on civilians and hospitals. This highlights the urgency of our gathering and the need for immediate and decisive international action. The convention, the Genocide Convention, establishes obligations that are owed toward the entire international community, known as erga omnes obligations. Some countries like South Africa, Nicaragua, have moved beyond merely issuing condemnations and casting votes. Can you hear me? Okay. And casting votes in the General Assembly. And we expect the same from all states, by taking proactive, practical steps at the bilateral level. This can be through joining South Africa in its goal, filing cases like Nicaragua against those involved and supporting the genocide, or taking diplomatic steps, such as reducing or cutting relations with the occupying genocidal state. Our meeting today is to discuss the obligations of the third-party states, and we look forward to clear recommendations for world states to take practical action to stop the genocide. This is not only a moral obligation, but also a legal one. Together, we stand at a critical moment, and I trust our dialogue will lead to decisive actions that alleviate suffering and uphold justice and human dignity. Thank you.
Thank you, Ola. We also have with us our next speaker, Mr. Sultan Al-Jammali, the Secretary General of the Arab Network for National Human Rights Institutions. Before I give the floor to you, sir, I just have one quick announcement to make that I missed at the beginning. There is simultaneous interpretation available. So in case you need to switch between English and Arabic, you can do so on the interpretation. Thank you. The floor is yours, sir.
شكرا. السيدة علا عدوي ممثلة رئيس الهيئة المستقلة لحقوق الإنسان في فلسطين، السيدات والسادة ممثلي الجهات الشريكة بالتنظيم، السيدات والسادة مقدمي أوراق العمل، الحضور الكريم، السلام عليكم ورحمة الله وبركاته. تنظم هذه الندوة بمناسبة مناقشة مجلس حقوق الإنسان للقضية الفلسطينية تحت البند 7، ويصادف انعقادها خلال أيام شهر الخير والسلام، شهر رمضان المبارك. وشعبنا العربي الفلسطيني في هذه الأثناء يتعرض لأقصى وأبشع أنواع الجرائم والتي ترتكب على مرأى ومسمع من العالم، والتي ستبقى وصمة عار في جبين الإنسانية لما فيها من تنكر لقيم ومبادئ الشرعة الدولية لحقوق الإنسان. هذه الشرعة التي بقيت طوال هذه المدة مجرد حبر على ورق عند طرح قضية فلسطين النازفة. لذلك أتينا اليوم لنعيد تذكير الدول بمسؤولياتها كأطراف ثالثة بالقانون الدولي. علنا نحفز صحوة الضمائر لوقف الانتهاكات الجسيمة التي يتعرض لها الشعب الفلسطيني. السيدات والسادة، لقد آزرت الشبكة العربية للمؤسسات الوطنية لحقوق الإنسان منذ إنشائها عضو الشبكة الهيئة المستقلة لحقوق الإنسان في فلسطين بسياق دفاعها عن حقوق الإنسان في فلسطين المحتلة. ونظمت الشبكة بهذا الخصوص عددا من المؤتمرات والندوات لدعم قضيتنا الفلسطينية، كما أصدرت عشرات البيانات والمخاطبات للمجتمع الدولي والمنظومة الدولية لحقوق الإنسان، تدين من خلالها الانتهاكات المستمرة للاحتلال الإسرائيلي، مطالبة بمحاسبة مجرمي الحرب الإسرائيليين، وأن يطلع المجتمع الدولي بمسؤوليته لإنهاء الاحتلال ومعاناة الشعب الفلسطيني وتمكينه من تقرير مصيره، وذلك وفق قرارات الشرعة الدولية. وقد استمرت الشبكة العربية بجهودها خلال العدوان الأخير على قطاع غزة منذ 7 أكتوبر 2023، وذلك بالتنسيق مع الهيئة الفلسطينية، عاملين من خلال المؤسسات الأعضاء في الشبكة على حث الدول العربية لوقف التطبيع واتخاذ مواقف وإجراءات تجبر الاحتلال على إدخال المساعدات الإنسانية الكافية لقطاع غزة. كما توجهت الشبكة العربية للمدعي العام للمحكمة الجنائية الدولية للقيام بواجبه بخصوص جرائم الحرب في قطاع غزة في سياق القانون الدولي الإنساني. كما اجتمعت بهذا الخصوص مع المفوض السامي لحقوق الإنسان، وكذلك وجهت عدد من الكتب للجان الأمم المتحدة وآلياتها، مطالبة باللجوء لآلية الإنذار المبكر والدعوة إلى اتخاذ إجراءات عاجلة لحماية المدنيين. السيدات والسادة، مع الأسف جهودنا وجهود مناصري الحق الفلسطيني لم تكن كافية لوقف العدوان الإسرائيلي على غزة، وحتى إنها لم تسهم في إدخال المساعدات الإنسانية الكافية للمواطنين المدنيين في غزة، حتى أصبح كل من فيها تحت وطأة الجوع المميت، وذلك بسبب ضعف أدواتنا بمواجهة المصالح السياسية والاقتصادية لبعض الأطراف السامية المتعاقدة على اتفاقية جنيف الرابعة بشأن حماية المدنيين وقت الحرب، حيث طغت مصالحهم الاستعمارية على الوفاء بالتزاماتهم القانونية والأخلاقية، مستمرة بريائها حول احترامها لحقوق الإنسان. لذلك نجتمع اليوم مع حضراتكم علنا نجد السبل لتنفيذ أوامر محكمة العدل الدولية ولوضع الدول عند مسؤولياتها كأطراف ثالثة في القانون الدولي، بما يسهم في منع الإبادة الجماعية في غزة ووقف العدوان وتوحيد الجهود لفتح الممرات آمنة لدخول المساعدات والجهات الإغاثية. والتعاون مع مساءلة ومحاسبة مجرمي الحرب الإسرائيليين وشركائهم. والله ولي التوفيق، والسلام عليكم ورحمة الله وبركاته.
Our next speaker for this morning is Giulia Pinazauti. She is an expert in international criminal law and international tribunals and is an assistant professor in public international law at the Leiden University. She will talk to us today about the responsibility of third states in enforcing the ICJ Provisional Measures Order. Giulia.
Thank you. So I'll address the steps that third states can take in the ambit of ICJ's proceedings specifically, with a particular focus on intervention. Unfortunately, there are not very many other steps that third states can take to enforce the court's order. The institutional framework is such that the way in which we can address non-compliance with provisional measures orders is very unsatisfactory. The court basically addresses it in its decision on the merits, and often a declaratory judgment is considered enough just satisfaction. So what can third states do to enforce compliance, and is intervention helpful? The first thing I'll say is that starting or participating in an ICJ case could be considered a way to fulfill the obligation to prevent genocide. And this is something that South Africa and Nicaragua hint at in their applications. Now, I'd say it's hard to conceive it as a duty to intervene as Nicaragua presented it, because it very much depends on the legal situation of the state. Whether this step is effective in enforcing compliance is a different question. If we look to other cases in which there was a significant number of third-party interveners, like Ukraine, Russia, 32 states intervened, or Gambia, Myanmar, 7 states, I would say that didn't have a positive impact on compliance. So interventions will not necessarily help in enforcing the court's provisional measures order, but they have an important expressive function. They send a message to the respondent state, to the international community as a whole, that certain violations of international law are unacceptable and will not be tolerated. It's often said that interventions, and particularly when they are mass interventions, are motivated by political considerations rather than considerations of a legal nature. But I would say that there is more to them, to the extent that they reaffirm the importance of the obligation breached, like the obligation not to commit genocide, to prevent genocide, not to incite in the commission of genocide. They have an important normative function. Now, one factor to consider are the changes that were recently adopted by the court to its rule of court concerning intervention, and the implications that this might have for states that are considering intervention. There's small changes, but they're significant. The first one is a change in the time limit of interventions, so I won't dwell on this any further. More significantly, it's a slight change to the wording of Rule 86 that gives the court the power to decide whether intervening states can appear or not during the oral phase of proceedings. This change seems to be a reaction to the mass interventions in Ukraine and Russia to avoid a repeat of that situation, because from the perspective of the court, interventions complicate the procedure and the arguments are often repetitive. If the court were to limit interventions to the written phase of proceedings, I think this would limit the expressive function of intervention that I talked about, because I see it as being at its highest during the oral phase of proceedings. These changes were only introduced less than a month ago, so we have to see how what effect they have in practice. But one way for intervening states to alleviate the administrative burden on the court and to avoid repetition in arguments is to make joint submissions or to coordinate their arguments. So something to think about. Now, in this new setting, maybe public and formal expressions of support could become an alternative to full-fledged interventions. But I'd say that one thing doesn't necessarily exclude the other, and there remains merit in interventions because there is value in making a submission before a court of law using the procedures provided by its legal framework. Finally, I wanted to offer some brief thoughts on what type of intervention would be most useful. There are two avenues for states to intervene in ICJ proceedings. Under Article 63 of the statute, states may seek to influence the court's construction of a convention to which they are party, like the Genocide Convention in this case. But with this type of intervention, intervening states can only make submissions on the interpretation of the Genocide Convention. They cannot put evidence before the court to substantiate the allegations against the respondent, against Israel. And they're bound by the interpretation that the court will give to the Genocide Convention. This is a well-tested mechanism for intervention. The second type of intervention, the second avenue, is provided by Article 62 of the statute. This is what Nicaragua did in the South Africa case. In this case, under Article 62, the intervention is not limited to making arguments on the interpretation of the Genocide Convention, but it has a broader scope. But there is no right to intervene. The court decides on the application, on the request, and I would say has a wide discretion to decide. Whether a state is admitted to intervene or not depends on showing an interest of a legal nature which may be affected by the decision in the case. What this means, unfortunately, is not clear. It's not clear also if the fact that the obligations in the Genocide Convention are erga omnes, as was mentioned, and all states have an interest in their compliance, is it sufficient to show an interest of a legal nature that would be sufficient for intervention? We don't know yet. The court has never addressed this question. Interventions under Article 62 are very rare in the history of the court, and the vast majority of them was rejected so far. So there is a risk. A further strategic consideration for states would be whether to intervene as a party to the proceedings or as a non-party. Nicaragua's request for intervention is to intervene as a party to the case. And it's actually the first time in the history of the court that there is a request of this time. It's not very clear why Nicaragua pursued this avenue, but what is clear that interveners as a party can make submissions on the responsibility of the respondent state, but then are bound by the judgment. So to recap, I would say intervention has an important normative function. There are two avenues under Article 63. It's easier. There's only one box to tick, being party to the convention, but then the submissions are limited to the interpretation of the Genocide Convention. And under Article 62, the scope of the submissions is broader, but there are more hoops to jump in order to intervene. Thank you.
Speaker for this morning is Omar Shakir, the Israel and Palestine Director at Human Rights Watch. He will be speaking to us about the perspective that Human Rights Watch brings, because last month they already put out a document that stated that Israel was in breach of at least one of the provisional measures order. So, Omar, he will be joining us online.
Thank you, Anisha, and my thanks to Law for Palestine, ICHR.
Yeah. Perfect.
Can you hear me okay? You can hear me okay? I will proceed then. My thanks to Law for Palestine, ICHR, and the Arab Network for Human Rights Initiative for sponsoring this event and inviting Human Rights Watch to take part in it. Human Rights Watch last month documented, as many other human rights groups have done, that the Israeli government is not complying with the binding provisional measures set out by the International Court of Justice. Our finding was based on our research that the Israeli government is using starvation of civilians as a method of warfare, which is a war crime, a report we put out in December. Pursuant to a policy set by Israeli officials and implemented by Israeli forces, the Israeli government is deliberately impeding the entry of humanitarian aid. They are blocking food, water, and fuel. These are also separate war crimes of collective punishment and the deliberate blocking of life-saving aid, as well as apparently deliberately razing agricultural land and making unavailable objects necessary for human survival, like bakeries, wheat mills, and water infrastructure, all pursuant to statements from Israeli government officials indicating that it is doing so as a strategy to accomplish its objectives during these hostilities. In the weeks following the International Court of Justice's ruling, the Israeli government has not only failed to address these grave abuses, but in some cases it has gotten worse. Our report looked at several different metrics, including the entry of trucks, including the continued failure to provide electricity, the continued limited access to clean water, the inability of aid trucks and convoys to reach northern Gaza at a rate that was decreased as compared to late 2023, the clear strategy of the Israeli government to undermine the work of UNRWA, the major provider of humanitarian services in the Gaza Strip, its attacks on aid convoys and killings of Palestinians queuing up for aid. The list goes on, but the answer is clear that the Israeli government is not complying with the provisional measures. Now, the Israeli government has given a range of excuses. It's blamed the UN. It has blamed Hamas for diverting aid. It has blamed the security situation in Gaza. But as the occupying power under international humanitarian law, the Israeli government is responsible for providing for the humanitarian needs of the population, for restoring public order, and for providing for the welfare of the population. Just as its forces and its bombs can reach all parts of Gaza, the aid can reach all parts of Gaza. And aid drops and building a pier are not sufficient to deal with the depth of starvation. The IPC in its recent report has underscored the imminent risk of famine. The Gaza Health Ministry has already documented 31 Palestinians, including 27 children, who have died as a result of malnutrition and dehydration. These measures by the ICJ are binding. They're binding based on the own terms of the court's ruling, but also pursuant to the language in the UN Charter. To be clear, while the UN Security Council is notified of the ICJ's decision, there is no further action required from it in order for this decision to be binding. But like many different decisions made by international bodies, enforcement is always a challenge. Enforcement in this case is ultimately up to individual states. States should use all forms of leverage, including imposing an arms embargo on the Israeli government, targeted sanctions on Israeli officials, its trade and bilateral relations, political statements, and all other levers at its disposal to press the Israeli government to comply with these binding measures. These measures include not only ensuring humanitarian aid and basic services, but preventing genocide, not committing genocide, preserving evidence. It also includes the duty of the Israeli government to punish incitement to genocide. These are really critical duties and obligations. In addition, UN bodies can take action to help increase the cost on the Israeli government and to help push for enforcement of these measures, such as a General Assembly resolution that can call for compliance with and press for compliance with the provisional measures. States should also speak out in support of these proceedings. The gravity and severity of the abuses on the ground warrant the International Court of Justice looking into violations under the Geneva Convention and under the crime of genocide. But I also want to be clear, and I'll conclude on this point to save time for the other esteemed colleagues. that states need not agree with the merits of the case in order to support these proceedings. Even if a state has yet to take a position on whether or not Israel's abuses in Gaza amount to the crime of genocide, it should support this vital inquiry by the world's court to see whether or not violations under the Genocide Convention are taking place. Indeed, these are duties for signatories of the Genocide Convention to prevent genocide. But in addition, this is exactly the sort of proceeding for which the International Court of Justice was created to hear. And in the current moment, the Israeli government is acting in defiance of the International Court of Justice. This poses a challenge not only to Palestinians and civilians across Israel and Palestine, but it challenges the very rules-based international order that we rely on for civilian protection across the globe. With yesterday's resolution at the UN Security Council calling for an immediate ceasefire, which the Israeli government clearly is also not complying with, we are seeing a frontal challenge to the very institutions that arose out of the ashes of World War II and are being destroyed in the rubble of Gaza. It is a critical moment for states to act to prevent further mass atrocities. The lives of millions of Palestinians hang in the balance. Thank you.
Much for your very powerful intervention, Omar. We will have questions in the end, I'm sure. Our next speaker today is Rula Shadeed. Rula is the co-director of the Palestine Institute for Public Diplomacy, which is also a partner with us at Law for Palestine and the ELSC at the Justice and Accountability Initiative that is looking at different accountability mechanisms present everywhere. Thank you, Rula.
Hello. Yeah, you hear me well? Okay, so first I would like to apologize for the late entry, another UN bureaucracy that we can deal with. The second, I would like us to please take a moment to have a minute of silence on the over 33,000 Palestinians, our brothers and family who have lost their lives in this genocide. Okay, so I guess you have heard our distinguished guests as well speak about the different mechanisms internationally about what can be done. In the situation of Palestine for the past 75 years, there has been many mechanisms that we know of. We have been part of even establishing, whether it is UN agencies, whether it is states, whether it is individual scholars, jurists around the world, that has been putting out different jurisprudence and disciplines of what can be done in situations of war, in situations of armed conflict, in situations of even in times of peace. There are many different frameworks. So let us begin by saying that all of these are tools. But these tools are definitely, unfortunately, as we can see, tools that are extremely politicized, which is something that we see not only in Palestine and the situation of the colonized situation in Palestine, but also we see it in other places. And this is very much related to, okay, so what is the politics around it? What are the interests in this particular situation? So in Palestine, and especially for the past 75 years, both domestically and internationally, there has been a failure after another on holding the perpetrator accountable for its atrocities, whether it is for Palestinians living inside Palestine or it is against Palestinians also living outside of Palestine. Let's remember that in the Oslo Agreement, despite the fact that it is not an applicable agreement that is being respected by our occupiers, still it says that the Palestinians do not domestically have jurisdiction over any Israeli that commits any crime on the Palestinian Authority or the Palestinian occupied territories, which is the 1967 territories. So if an Israeli ID holder, an Israeli person commits a crime within the areas of 67, they cannot be tried by the Palestinian domestic courts, which leaves us domestically with only one jurisdiction or only one court system, which is the civil Israeli military system, or the civil system, the civil jurisdiction and civil courts within Israel, or the military courts in the 1967 area. Now, about 98% or 99% of the cases that have been submitted to Israeli courts, whether it is specifically military courts, have not had any sentence. So no Israelis were actually held accountable in relation to these cases. Okay, so this is very much related also to the principle of complementarity that we also think about when we think about international justice tools and international courts and so on. So this leaves us with another mechanism that has not been used very widely for many different reasons, but either we use domestic courts in different states around the world, such as this country here or any other courts around the world, or we use universal jurisdiction when there is no nexus between the person who has committed the crime and the country that is willing to actually submit a case against them. So what we have done in the Palestine Institute for Public Diplomacy, PIPD, is that together with the European Legal Support Center and Palestine and Law for Palestine, is that we have decided to look into how can we complement and emphasize on the importance of domestic laws and national courts to actually take to court and try to petition perpetrators on 5 different categories. So the 5 different categories are officials that have been very complicit, whether in their statements, official or non-official. Also officials that have decided to take and sign agreements with the Israeli perpetrating state to actually go ahead with support of whether it is political, economical, or specifically arms trade agreements within also the period of the ongoing genocide on our people. The second is companies that have also decided to either continue their relationship with the Israeli colonizing state or double up their agreements and support with arms, etc. It is also very important to think of the news agencies, and we have been seeing how much complicit the news agencies. We've just seen the report that was leaked yesterday, or maybe not even leaked yesterday, that says about the complicity of the New York Times and their journalists. And this is just a mere example. There are so many similar cases that we see in the news that is trying to use a certain narrative that is definitely in support of the perpetrator and in total negligence of the victim and of our Palestinian people. The third is also the dual citizens. So we are seeing a lot of dual citizens that are actually voluntarily going and participating in the Israeli occupation forces in the ongoing now genocide on Gaza. And these people, according to even national and domestic laws, it is very clear that you're not supposed to participate in an army that is actually committing or plausibly committing an ongoing genocide. But even if a genocide was not ongoing, even on the level of crimes against humanity and war crimes, you're not supposed to be participating in those atrocities and activities. And the last is whenever all the above are not related, there's no nexus, meaning no connection between this person, the four categories that I just mentioned, and the country, you can actually go and use universal jurisdiction. Now, in 2009 and 2008, 2009, there has been a very interesting and it was promising in a way to see that universal jurisdiction was actually used in several European countries and states. But unfortunately, And non-surprisingly, those European states within their legislative systems have changed the laws to make it even harder for the universal jurisdiction to be applicable. And I say it's unsurprisingly because I think everyone here in the room knows exactly why. But this definitely does not mean that it is impossible to go through these tools using universal jurisdiction. And now with the ICJ decision, it is very, very crucial and important to know, understand, and remember that most of the states have the obligation, as the panelists have already cleared out and said, states do have the obligation to not aid and abet or support or be part of, in any way, complicit with the ongoing genocide. Now, this is very important. I'll end by saying that it is important for us to understand and acknowledge that there are so much that can be done. So whenever we go and speak around the world, there's always this question, so what can we do? There's nothing we can do. It is a very political situation. But actually, there is a lot that can be done. I'm not sure. I can see that there are different people in this room, representatives of states, UN agencies, and maybe NGOs and so on, and individuals. You do have the possibility to actually be a plaintiff in a certain case. And there are many, many cases, unfortunately, within each of your country's jurisdictions. I'm guessing most of you are from this continent. So there is a lot that can be done, and you will find many ways. And I do invite you and encourage you to at least show that Europe has the least respect for the rule of law that we can't see on international level and on a political level. Thank you.
Thank you so much, Rula. Our next speaker for today, the last speaker for today, and definitely not the least, is Francesca Albanese, the UN Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967. I feel like that is more introduction than anybody needs in this room for now.
Yes, I think that I made my presence noticed in the last months. So good afternoon, everyone. Good morning, everyone. I'm a bit at loss because everything I wanted to say has already been said by my distinguished fellow panelists. So I take this opportunity to take a step back and bring to the fore two reflections. The first is something that you will find in the report that I just, that I will present today to the Human Rights Council. And this is a tragedy foretold. What laid bare in Gaza is something that is absolutely shocking. Oh, yeah, sorry. Can you hear me? It's something that is absolutely shocking, but is not surprising for a number of reasons. First of all, because, and I say that with some regret as a lawyer myself, in the pursuit of rigor in our discipline, we have approached the various crimes that have been flagged, that have been denounced by Palestinian human rights organizations, international and Israeli human rights organizations as different issues to deal with while they were symptoms of the same problem. So, settler colonialism, apartheid, now genocide, and a litany of war crimes. There is, I keep on saying, even the stones of this building could recite by heart all the crimes that have been committed in 50, 60s plus against the Palestinian people. And this doesn't mean that the Palestinians have not committed crimes against Israelis, but the overall framework is that of a settler colonial enterprise, which has been justified under the guise of military occupation and which has frustrated the right of self-determination of the Palestinian people through and through, demographically, economically, politically, culturally. This is the reality. And apartheid is a word that South Africa has given to the world, but it exists. It's the spine of settler colonialism, because discrimination, institutionalized, structured discrimination so that one group dominates another. This is intrinsic in settler colonialism, and genocide is the dormant gene of settler colonialism. It's there. if by genocide we understand the ultimate act, the ultimate stage of annihilation and elimination of a people. And certainly everything was there as human rights organizations, NGOs have documented forced displacement, mass killing, mass destruction. And this is something that the Palestinians have endured, bear in mind, since 1947. For some of us, it was a professional act of compliance with our duties. But this is the life they have endured as a people. And frankly, I take the blame, but I also share it with you for not using on time the words we were supposed to, for limiting ourselves to the confines of, oh, we cannot talk about apartheid simply because you would lose funds. But this has been the life of these people for decades. And here we are. And I beg you, don't turn your eyes away. Don't commit the same mistake. Because genocide is true. It's a difficult crime to prove. Because there is a higher threshold to prove intent, but not when the intent is in our face. And this is the second thing, here I come to the second thing I wanted to say. And this is directed to the states among you. The Genocide Convention contains an obligation to prevent, not only to punish, the crime of genocide. We have already failed. You have already failed to prevent genocide. Let's be clear. It will be up to national courts to determine, or the International Criminal Court to determine who on the member states who have supported, provided military and financial and political aid to Israel as it was clearly committing genocide. At least as of the 26th of January, exactly 2 months ago, the court, International Court of Justice, put all of you on notice. So you cannot say that you didn't know. Even if you got distracted, harassing UNRWA, the only agency that had the capacity to deliver critical aid to the Palestinians in need. A number of member states have still to atone for it, have not resumed funds. So this is not just making mistakes, it's persevering. But again, courts will judge those responsible, hopefully. But meanwhile, I want to say, the Palestinians and also the Israelis, because the day they will realize what they have done, it will be a very painful day and very painful process, and will have to be even-handed to these people, to anyone. The Palestinians and the Israelis, justice will have to be done. But again, I do not expect easy years ahead of us. The Palestinians had been failed also, as you denounced or you acknowledged, war crimes. Because even the Geneva Conventions have an obligation, create an obligation to respect and ensure respect of the norms contained in those conventions. So again, it's up to you now to take action and to ensure that no more blood is spilled in the land on all sides, and take the measures, economic, political, and diplomatic measures that are absolutely necessary to put this bloodshed to an end and allow people in the region to resume life. Thank you.
So much for your powerful intervention, Francesca. We have time for about maybe 2 or 3 odd questions. So if there is anybody, anyone else? Yes. Yes, I see it. I'm going to give you the floor. I'm just wondering how to do that. So perhaps you can come here and introduce yourself.
Hi, Hector Sharp, Legal Advisor to UNRWA Gaza Field Office. Hi, Francesca. Last week, we sat here 100 meters from this room, and we listened to the Israeli Permanent Missions event on humanitarian aid in Gaza. My former counterpart, Major Lior Salama, sat there and told an audience, which included many of the states here today, that there is no famine in Gaza, that aid is getting through at a rate 80% higher for food than prior to the conflict. Many states were there. There was room for questions, and not one state spoke up in defense of UNRWA, in defense of Palestinians, and to correct inaccuracies of what we've just been subjected to for an hour. My question to the panel is this not a perfect example of where states have the platform to abide by their obligations under the Genocide Convention and under international law? Thank you.
Thank you. I will actually check if anybody on the panel wants to take that. Omar? Yes, please.
Thank you for that intervention and for the vital work that UNRWA is doing under really incredibly difficult circumstances. Look, the facts are pretty clear cut. In the 3 weeks before the ICJ ruling, there were about 147 trucks per day entering Gaza. In the 3 weeks preceding, it dropped under 100 to about 90 trucks per day. In March, it's increased slightly to about 150 or so, 157 trucks a day so far in March. But let's remember, before October 7th, 500 trucks a day were entering Gaza. And let's remember, before October 7th, Gaza was under a 16-year closure where 80% of the population relied on humanitarian aid. Before October 7th, goods were coming back and forth out of Gaza. Farmers were accessing agricultural land. Life was going about as normal. So yes, there has been a slight increase from March as compared to February, but it's nowhere near meeting the needs of the population and nowhere near compliance with the ICJ's binding provisional measures. And certainly states who are cutting and suspending funding for UNRWA are contributing to the catastrophic humanitarian situation that's taking place. Other aid organizations have made clear that there is no supplement for the role that UNRWA plays. The fact that UNRWA is now not able to deliver aid the last few days to northern Gaza, really will have life or death consequences. We're talking about not only piles of Palestinian bodies piling up because of airstrikes, but now we're seeing people killed as a result of starvation. And that only threatens to get worse. Every projection projects the situation continuing to get worse, absent clear international action. And absolutely, I think states need to take action in light of their legal obligations and also in light of the ICJ's ruling.
So much. Just, I think I understood your question that you were surprised and angry with how no one actually responded to the allegations that the Israeli colonial state was actually stating, right? And you are asking if this is the platform that should be. This is, again, takes us back to the political will and the political interests. Even after 6 months of atrocities that are horrific, unprecedented to the Palestinian people, we are still seeing many, many countries either intimidated or does not want to be part of any type of accountability against the state of Israel. And this shows us what is the system we're actually living in. And this is now a conversation that is being held by many global majority, or what you like to call global South initiatives that are speaking about where are our voices? Why have we been kept out of the entire game? Because there's a certain system that is actually feeding into a situation of unaccountability, and impunity is becoming the norm. Because you think that now, if the Israeli colonial state does go unpunished, you think that this will not be encouraging other states to actually also take the exact same measures. And then, we'll be saying the only democracy in the Middle East has been doing this, so why not other states do it as well. So the answer to your question is, unfortunately, and I think you know it, is that the disgusting complicity of so many countries and states that are continuing to support this state. However, with the ICJ, we have seen that some states have been obliged, whether it is with, for example, the Dutch state, the Supreme Court had to actually push for the ending of the arms trade. So the state was not really supporting that decision, but then the Supreme Court did. So this is what we mean exactly by using the tools, domestic tools, because some states do still have a little bit respect for the rule of law.
Thank you, Omar and Rula. We have a comment from the state of Luxembourg. Please.
Thank you very much. I'm not sure I can speak for the entire state of Luxembourg, but I can speak as a diplomat who's active here at the Human Rights Council and has been doing this kind of work for about 20 years. First of all, thanks very much to all the organizers and the NGOs. And the Special Rapporteur, of course. You have been in this position for I think now 2 years, and also previously, and all of you have been ringing the alarm bells loud and clear. The early warning mechanisms of this council, but of civil society, always work, but it's the states that are not listening. This is where the system fails. The failure of the system, I want to say, and this is something that's been said many times over the last half year, is the failure of states, not the failure of the law, not the failure of the institutions. This is states that are not doing what they should do under the Charter, under the Universal Declaration of Human Rights, under the many different treaties we have to make sure that never again is now. I want to say to the colleague from UNRWA, and first of all, we pay tribute to the work of UNRWA and the immense and incredible sacrifices you have been giving at this time and for many decades. I may have been at the event that you mentioned, and I have to say, I was dumbfounded by what I heard. I had a question written down, and that was going to be, are you honestly telling us that Mr. Lazzarini, Mr. Griffith, everybody we've been hearing for the last 5 months are lying to us? But when the time came to ask it, there was no time. There was basically no time. I did ask my colleague from the mission for the slides that were presented at that meeting, and I haven't seen them yet. I live in hope that they may be shared yet. But honestly, I have very little hope that. I mean that they're not. They're not serious. This is not a serious presentation of facts. This is essentially what we've seen in so many other situations, in Sudan, in Ethiopia, in Yemen, in Syria, in all situations where states have decided that, in Myanmar, where states have decided that a particular group of people needs to be destroyed, and they do everything to distract and deflect and divert attention. So I unfortunately don't have a question. I do have an apology, I believe, for everyone who works in this position, which is that we're trying to do our best, but again, the distraction, the overwork, sometimes our laziness, I have to say, our sort of rebounding on what we have the kinds of geopolitical habits of saying, well, this is what the system is, and diplomacy is difficult, and all of this takes a lot of time, distracts us from the things that can be done. Things like saying, well, let's just roll the trucks across the border and see what happens. But of course, all of these demand sacrifices, and we should be ready to bring them ourselves. But thanks again for organizing this.
Thank you so much. If there is anybody on the panel who wants to add something, respond to something. No?
Be a very brief comment.
Yes, of course, please.
Just a very brief comment to echo what Francesca already said loud and clear. In the face of what's happening in Gaza, you know, the obligation to prevent genocide, or the obligation to ensure respect for IHL cannot be discharged by, you know, general warnings to Israel that they have to abide by their obligations under the Genocide Convention or IHL. It is not enough. You cannot, and I'm talking to state representatives, you cannot continue business as usual and think that you've discharged your obligations simply by saying, okay, we continue with the provision of military assistance, diplomatic support, financial assistance, etc., which is tell you to abide by IHL all your obligations under the Genocide Convention. It is not enough. Unfortunately, I grant you that it's not very clear exactly what you have to do in order to discharge your obligations under the Genocide Convention. That's the most important obligation in the convention, and 75 years later, so we don't exactly know what it means. But you have to use all the means at your disposal to make sure that the ongoing genocide stops.
Thank you, Giulia. If we're unfortunately at the end of our time, so if there is no other interventions, on behalf of Law for Palestine, Human Rights Watch, the Independent Commission for Human Rights, and the Arab Network for National Human Rights Institutions, I thank all the panelists for being here and bringing to us this conversation, and all of you for participating in this and hopefully taking what the panel has brought forward. Thank you so much.